Supreme Court of India Vipin Sahni and another versus Central Bureau of Investigation decided on April 8, 2024 SEC Online SC 511 facts of the case. On November 30, 2011, case was registered on the file of PSCBI, EO 1, New Delhi, under sections 420 and 120B IPC along with section 13(2), read with section 13(1)(d) of the Prevention of Corruption Act, 1988. This FIR was registered against the appellants and unnamed officials of the AICTE, alleging that the appellants had obtained approval by deceitful means from the AICTE, in violation of section 4.2(3) of the AICTE Approval Process 2006. As per this provision, the land approved for starting an educational institution ought not to be encumbered. After completion of the investigation, charge sheet was filed by the CBI for offences under sections 420 and 120B IPC, naming only the appellants as the accused. Magistrate discharged the appellants. High Court allowed petition filed by CBI under section 482 CRPC and set aside order of magistrate. Findings of the court: the sine qua non to make out an offence under section 420 IPC, insofar as the present case is concerned, is an act on the part of the appellants to cheat and thereby dishonestly induce the person so deceived, viz., the AICTE, to deliver any property. Therefore, the appellants, while applying for and on behalf of the society, should have either suppressed material information or projected incorrect information so as to induce the AICTE, by such dishonest means, to grant approval for its educational institutions. In the case on hand, there was disclosure of the fact that the subject land was mortgaged to secure the bank loan, but despite the same, the AICTE granted approval for the Business School of Delhi and it never complained that it was under any misinformation in that regard. Thus, the essential requisite to make out an offence of cheating is lacking. Mere carelessness on the part of the appellants in filling up the second and third applications and a part of the first application also cannot be taken to be motivated by deliberate deception, on the admitted factual position, so as to invite criminal charges. Further, there is no evidence of the appellants consciously agreeing or conspiring to deliberately furnish false information to the AICTE so as to garner its approval for their college's appellant number 1 filed the first application, divulging the relevant details of the bank loan and the mortgage over the leased land, but he failed to do so in the third application filed by him. Appellant number 2 filed the second application with the same non-disclosure, but there is no evidence whatsoever of the appellants resorting to deception in that regard willfully and in connivance with each other. Therefore, the charge under section 120B IPC also does not withstand judicial scrutiny. It was not open to the CBI to blithely ignore the statutory remedy available to it under section 397 CRPC, and thereafter resort to filing of an application under section 482 CRPC. Finding of the High Court is not supported by the admitted facts, which indicate disclosure of the mortgage at the outset when the first application was made, and, therefore, there is no possibility of inferring that the appellants conspired in terms of section 120A IPC to commit an illegal act of suppression so as to secure the approvals. Further, the AICTE itself never claimed that it was dishonestly induced to grant such approvals, and that essential link is altogether missing, whereby any such criminal charge of cheating can be sustained against the appellants. The criminal appeal is allowed.